Everyone, welcome to the May 23rd, 2017 Delaware Public Service meeting. First of all, we have a couple of 5-year service awards. If we could have Amy Woodward come up. We have, I'm sure it's some sort of a valuable pin here, but Amy has now worked for us for the state for 5 years, 1 month, 2 days, 5 hours, and 4 minutes.
You're on it. You're a little late.
So thank you so much.
Thanks.
Thanks, Amy. Attorney Loper is she's trailing just by a little bit. She's at 4 years, 11 months, 19 days, 5 hours, and 4 minutes. But we trust her so much, we're going to give her a 5-year pin slightly in advance. Thank you so much. We have the reading of the minutes of May 9th, 2006. Does that read right? It says 16? Let's check it. Let's take a wild guess and say it's 17. 17. And any changes or corrections to the minutes? A motion, please, to approve.
Move we approve the minutes of May 9th as corrected in revision 1.
Any discussion on the motion? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Any abstentions? And one person absent, by the way. Commissioner Conaway has got... she's on nurse duty right now. It's nothing major, just a little bump in the road for her husband, and he's going to go see the doctor, so she's helping out, and we'll see her next meeting. Joe is going to be fine. Okay, the consent agenda, and we have 4 items on the consent agenda. Does anyone want any of the consent items to come off the agenda? Or any questions about them? If not, could we have a motion to approve the consent agenda?
I so move that we adopt the consent agenda as indicated.
Second.
Is there any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Number 1 on the regular agenda is in the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and miscellaneous tariff changes. Mr. Goodman.
Well, as far as the order goes, Chair, Info, Commissioners, we're very pleased with it. We're very pleased that we were able to reach a settlement amongst all the active parties in the case. The final version of that is the other.
Okay, thank you, Mr. Goodman. I guess Mr. Geddes is next.
It's your pleasure. Would you like me to go next? I don't have any problems per se with the order, but I did file an exception. I don't know whether you want me to deal with that now or at some other time.
Well, let's hear from Ms. Iori. Do you have any comments to make on the settlement?
Not on the proposed form of order.
Okay. Mr. Willard, I guess you have...
No, Your Honor, everything was fine with the staff.
Your Honor, I'll just introduce myself. I'm Mike Quinnan. I represent the Delaware Energy Users Group, which was a participant in the case.
Yes,
and we embraced
I apologize
the settlement order.
for not recognizing you right off. I should have. Thank you.
No trouble.
Okay, Mr. Geddes, you're causing the problems here today, so give me a suggestion. How do you want to handle this thing?
Your Honor, I'm going to try to be efficient. I said try. And try to tee up the issue for you that staff has, and then I would assume you want to hear from Ms. Iori, and I would like to reserve an opportunity to at least comment on what she has to say. If that is acceptable to you.
That sound fair, Ms. Iori? You get to speak once, he gets to speak once, plus a little bit.
I'm older. Respect your elders.
Your Honor, I may ask for Sir rebuttal to his rebuttal. Obviously, it is the Commission's choice as to whether to give it to me.
That wouldn't shock me. But Mr. Geddes, why don't you kick it off and let's see what we can do with this.
All right. members of the commission, obviously you've read the exceptions filed not only by staff but by the DPA. I want to try and narrow the issue to what I think is before you and the reason why staff did file an exception. And it really has to do with the reasoning of the hearing examiner with regard to this issue as to whether Mr. Gorman's testimony should be admitted or not. And his statement in a footnote on page 20, footnote 6, where he comes up with two reasons why, over staff's objection, to admit the testimony. Now, there's a lot of other things in the exception, but what staff wants to argue and have you focus on are the two reasons that he cites as why he believes the testimony should be an exhibit. Not that it shouldn't be referred to, not that it can't be relied on, but it's an exhibit as a piece of evidence in this case. Now, the first argument, I would say first sentence phrase, is that staff was a settling party. And if you read the hearing examiner's report, you know that on March 7th, staff was not a settling party. It was a contested settlement. And on March 8th, based on additional negotiations that happened on March 7th, staff negotiated a new agreement with Delaware, which all the other parties signed on to. Now, the import of that, and it's not only for this case, but it's also for future cases, is that staff's right to stipulate, which is an agreement. It's not conditioned. It's not subject to restrictions. It is an agreement. I stipulate that my tie is red. That doesn't mean that somebody else may disagree, or a color of a dress, or whatever. And stipulation is an agreement. And what the hearing examiner said over staff's objection was that because staff was a settling party, it was not able to object to a piece of testimony coming in the record. Now, if you carry that to the logical extreme, that means that all pre-filed testimony would have to come into the record. That a party, no matter what was in the pre-filed testimony, could not object to it. Because he's saying, you are a settling party, therefore the testimony must come into the record. And if you had a rate design issue that, and I actually, Mr. Quinlan was talking about this before, he came to make sure that we didn't jigger the rate design so that his clients paid more than sister average rate of return. The point is, somebody could recommend something that was extreme, and by taking this particular logic to its ultimate conclusion, that testimony would have to come in. And under the APA, the commission or its staff or whomever would have to deal with it in its final report or order, because you are supposed to analyze all of the evidence in the record, and including that in support of a proposed settlement in a contested matter or uncontested matter. The second reason really conflates on the first, and that is he refers to the usual and customary practice in an uncontested case that parties stipulate testimony into the record so that certain witnesses don't have to appear to save on time and expense. Well, that's not what happened here, because staff objected to it. And staff does not have to explain its objection. It is not required to stipulate to all testimony, pre-filed testimony. There's no rule, there's no regulation, and there's no case decision that the hearing examiner cited to you to support his conclusion. Now, I did a little diagram, and of course I'm not a very good artist. Fortunately, I didn't have to make my living this way. And I will move around for Gina, and others can see it.
Tom's head's in the way.
My head's in there, Tom's head.
It starts early. So, and this sort of looks like a TV back in the 40s and 50s. In any event, we have a settlement. And we have stipulations, and we have pre-filed testimony, say 1 through 20. So what the hearings, and the two reasons that the hearing examiner gave, one was, because you're a party, and two is because of customary practice. So what's the import of this decision? I'm not talking just this case. I'm talking about cases in the future. If you settle, you can't do this. You can't stipulate. You're not allowed to. You can't, in the positive you can, but you can't do the negative, which is you can't object or non-stipulate. So in essence, he's restricting our ability to talk about any of these exhibits, whether they relate to the settlement agreement or whether they don't. If you follow his decision, we are a party to this settlement, an improved settlement, I would say, the March 8th versus the March 7th, irrespective. You can't do this anymore. Without that decision, normally you stipulate pre-filed testimony and it comes in to support that. Just going like that, you just split it. That can't be right. And no one has addressed the issue because no one's ever seen this before. There's no cases, no regs, no nothing. You can't. This can't be right. And you have to ask yourself, is this the policy you want this commission to follow? Because when you make these absolute rules, you settle, therefore you have no right to comment on the pre-filed testimony. There may be a situation where you want to allow that to happen. And you don't need to do it in this case. This is a case that has come to resolution after a lot of what I call hate and discontent. I don't mean the hate so much, but a lot of discontent. And it just seems ironic that now we would take a settlement, an uncontested settlement, and put this on top of it for no reason. Now, the second reason conflates onto the first. He basically says, well, in uncontested cases, you stipulate the testimony in and we try to, be efficient. Well, that's not this case. We didn't stipulate the testimony. We said we object to it. So this conflates into that. And that goes away. It can't work any other way. Now, the exceptions are based on what the hearing examiner reasoned to be the conclusion in this case. Ms. Iori, on behalf of the DPA, cites the Artesian case. Now, the Artesian case came to us January of 2016. And in a very lengthy opinion, the commission said a couple of things. It said this was a case of first impression. Paragraph 321. Normally, we have this situation, which is people stipulate testimony and yada, yada, yada. In the Artesian case, if you remember, we had a substitution of witnesses just before the hearing, where the witness that had filed 3 sets of testimony was replaced by another witness. And the DPA and the staff filed objections. And in paragraph 321 of that decision, you said, well, this is a different case. It's not this one, the usual case. This is where you have a substitution. And in paragraph 323, basically said, look, we're going to allow it in this case, but this is not going to be the rule. This is an exception. Case of first impression will allow it, but admonish the parties not to do it again. And that's in there. Not necessarily referred to in some of the exceptions, but I can give you that. Excuse me, sir, if I don't mind, in case you want to see it. Because I think this will probably come up in some of the comments that Ms. Iori will make too. This is just the excerpt beginning with your discussion and decision on the issue of the substitution of a witness. So, as I was saying, 321 is where you make the distinction between that case and the normal case. 323 is where you, in essence, talk about how this is a case of first impression. It's one of the comments I made in my exceptions, because I did not think that this case here was necessarily that case. But the thing I want to focus on is 324, and that's where you admonish, I'm using the same verb again, but the hearing examiners in the future to set forth their reasons as to why they come to their conclusions with some specificity. And I believe in that case you had some concerns about the hearing examiner going outside the record and some other things. My only point in citing that is we don't have any analysis. We have nothing. We have a footnote. It has 2 sentences in it. And you have Exhibit A attached to our exceptions, which is the complete analysis that the hearing examiner used to come to this conclusion that somehow staff did not forwent its ability to object to a piece of testimony because it was a settling party. So in conclusion, it's not necessarily this case that staff's concerned about. It's the cases in the future similar to that analysis there, which is, look, we really don't want to go down this road again with substituting witnesses at the last minute. Let's, parties, let's see if we can avoid this. We don't want to make a habit out of this. And this is the only case where I believe where a party did not stipulate to a piece of testimony. It was ruled on and is coming before you now. I just don't think this is good policy. You're then, in essence, saying if you're settling, you can't comment on any pre-filed testimony, and the further import of that is it all should come in. There shouldn't be any, do you object to the testimony, do you stipulate no objection? It's irrelevant because you settle, you forego any kind of stipulation, and that's what his opinion says, and that can't be right. Thank you.
Thank you, Mr. Geddes. Ms. Iwery?
Thank you, Chairman, fellow commissioners. I'm not really sure where to begin because this is all new argument. None of this is in the exceptions to which I responded. So I will try to address what
Point of clarification,
Mr.
Your
Geddes.
Honor. It's in the issue presented in my section. It's exactly laid out.
None of the argument that Mr. Geddes just made is in the exceptions. If it was, I would have responded to it. I feel like I spent a lot of time working on exceptions to what was in, or working on a response to what was in those exceptions, none of which has been addressed in this argument. That having been said, I think Mr. Geddes doth protest too much. Yes, the hearing examiner said 2 things. Keep in mind that this was in the middle of a settlement hearing, and he didn't have time to write a nice long order as to why he was including the testimony. But this commission's norm, as it says in the Artesian case, is that in a unanimous settlement, which this was, regardless of how we got there, this was a unanimous settlement, all of the testimony comes in. Now, if Mr. Geddes wanted to object to it, and he did, the hearing examiner allowed him to put it in anyway. Mr. Geddes could have addressed that testimony. He could have addressed it with the witness that adopted it. All of the witnesses that were put up in the settlement agreement adopted the testimony of that party's other witnesses and were subject to cross-examination on it. Our witness, Glenn Watkins, who has actually served as a rate of return witness in cases before this commission, adopted the testimony of Mr. Gorman and was prepared to be cross-examined on it. Staff chose not to cross-examine him on it, but that was their prerogative. He could have been cross-examined on it, and if staff did not like what they got from him, that could have been addressed in the hearing examiner's report. Nothing like that happened. Now, I haven't heard any reason as to why, and I think Mr. Geddes said that, if I got this right, he said that testimony would have to come in even if there was an extreme position, and that that staff does not have to explain why it objected. First of all, if there was an extreme position in a unanimous settlement, the settlement agreement itself provides that any issues raised are, and unfortunately I don't have it in front of me at the moment, but the settlement agreement itself provides that any issues raised in the testimony or that could have been raised doesn't matter. Doesn't matter. So that issue, that's a non-starter. And that's in the settlement agreement that staff agreed to. Secondly, staff does not have to explain why it objects to a piece of evidence that's coming in. There's no authority cited for that. And certainly, in any case in which a party objects, the first thing that the trier of fact is going to ask is, what is the basis for your objection? So yes, I think staff does have to explain the reasons why it objected. Now, Mr. Geddes did explain on the record the reasons why he objected. I responded to those reasons, and the hearing examiner decided that he was going to allow Mr. Watkins to adopt Mr. Gorney's testimony and to admit that testimony as an exhibit. And as I said, Mr. Watkins was made available for cross-examination, and staff chose not to avail themselves of the opportunity to ask him questions about it. Again, staff's prerogative, but they cannot now be heard to complain about it. Now, staff said that this is an issue that may come up in other cases. This is perhaps the first, it's not the first substitution of witness example, as Mr. Geddes explained, and as I explained in my response to the exceptions. The commission allowed this to happen in Artesian. That was a contested case. And so, of course, the commission doesn't want substitution of witnesses in contested cases. This was an uncontested case in which the practice has been that one witness gets up and adopts all of the other witnesses' testimony. Staff did that. In fact, staff put up a witness who hadn't even submitted pre-filed testimony to adopt its testimony in the case, and she was subject to cross-examination. Delmarva had 7 or 8 witnesses, I can't remember, but they put one witness up, Mr. Zeminski, who adopted all of the other witnesses' testimony and was subject to cross-examination. Now, nobody did, which is not surprising since it was an uncontested settlement. But what staff is suggesting in this is that parties are just going to have to bring all of their witnesses now, even when a settlement is uncontested. Because who knows when somebody's going to object to something, even whether the settlement is uncontested. That does not make sense. Part of the reason that you encourage settlements is to reduce the costs of a litigated hearing. That is not what staff is suggesting in this case, is not going to help that. In fact, I can see where it would make settlements more difficult as opposed to people being encouraged to enter into them. I don't know whether, since Mr. Geddes did not really make any of the arguments that he made in his exceptions, I don't know whether you want me to go through any of what was in my written response. I hope you had the opportunity to read it. I know it didn't get in until late yesterday morning. If the commission wants me to go through it, I'm happy to do so. I had picked out just a few issues that I wanted to hit.
Our very able secretary immediately sent it to all the commissioners via email, and I received it shortly thereafter and had occasion to read a very good brief that you wrote. And I'm just assuming that the other commissioners had a chance to read it as well. So,
I do have one thing that I do want to emphasize, though, and this was in staff's exceptions, but it was not discussed today, and that is what happened before the uncontested settlement hearing, because I think that really is the crux of why we are arguing about this today. And that is this. Prior to the uncontested settlement, we had a contested settlement. We had 3 parties that agreed to a settlement and 1 party that did not. You have heard that before in the interlocutory appeal that staff raised that the commission denied approximately a month ago. But what happened in that case was my client, in consultation with me, his counsel, decided that we were not going to bring our witness, our rate of return witness, to testify at a contested hearing, nor were we going to introduce his testimony. And staff then tried to subpoena him, and we objected. The hearing examiner never reached that issue. And ultimately, it did not have to be reached because there was an uncontested settlement. But we think that is what is driving this particular issue at this time. Even though staff did not make any argument on it to you today, they did make an argument on it in their exceptions. And I would respectfully request the commission, if it is going to consider these exceptions at all, based on the fact that there was nothing in the hearing examiner's report on this to which staff really could accept, even though staff had an opportunity to review the draft hearing examiner's report and add this in if it so desired. That is really what is causing this. And we would ask the commission, if it gets to the point of the merits on this we do think has an impact on other cases, and that is, are you going to let one party dictate to another how it is going to present its case? Thank you.
Limited, hopefully just 3 points. The issue is not about referring to Gorman's testimony. The issue is about saying it's an exhibit in the case. That's where staff is drawing the line with respect to putting an exception in front of you. We're not saying that if you're doing a normal objection, you don't have to have a reason. What we were saying here is we were not going to stipulate to the entry of the testimony, which is a shorthand for saying we were objecting to it. But a stipulation is different than an objection. If I'm not going to stipulate, I'm not going to agree, then something else has to happen. And the point is, when that was said, the hearing examiner said, well, you're a party to the settlement, so therefore you can't make that determination, or you can't say that and have it mean anything. That's what he ruled. And that can't be right. Yes, this was a very different case, because one day we were on the outs, staff, and the next day we were on the ins. And the day before, they didn't want to have anything to do with Mr. Gorman as part of the case because we thought he would be helpful to proving what the public interest was. And the day when staff settled, they wanted his testimony in. The point is, we just didn't stipulate, and there's nothing that says we have to stipulate. So now we roll over to what the hearing examiner said. And he did not address these other issues. It's not staff's responsibility to redraft his opinion. That's not but he didn't say that. I gave you page 130 attached to the exception saying that's what he said. That's what's in his report. He could have embellished it himself. He's the hearing examiner. He asked for comments, and he didn't take that opportunity. The point is that this is just a bad way to go about this, and I'm not so worried about this case. This one's resolved. It's the next case. And if you support the hearing examiner, are you saying in that decision that going forward that any party who settles cannot object to testimony, to any pre-filed testimony? Because that's in essence what you're saying, because that's what the hearing examiner said. So, an alternative is to this already indicates, well, I didn't discuss some of those issues. I think this is a seminal issue. Obviously, there are others, but I didn't want to go down that track. I figured that could be done in writing. But, one solution is ask the hearing examiner again to better develop this issue. But I just think it's a bad precedent going forward, and staff just can't support that rationale. Thank you.
Thank you.
May I have a brief rejoinder, Chair Winslow?
Yes, ma'am.
Thank you. I think we're talking about semantics here. stipulation, objection, whatever. Here is what happened. I went to move the testimony in through my witness, and staff objected, said it would not stipulate. The hearing examiner overruled him. That is an objection. That's all it is. This is no different. He could have ruled the other way. He could have said that I'm not admitting the testimony. He could have upheld staff's objection, but that is all it is. The second thing is, as Mr. Geddes just said, that I'm not concerned about it for this case because this case is settled, it's over. Well, then all they are asking for is advisory opinion that this commission has been loath to give. Thank you.
Mr. Goodman, do you have a dog in this fight?
Well, I do.
Well, then please explain to us.
Yeah, well, number one, we are the movement, we're the petitioner in this case. We are the ones that went through this with all the parties. We are the ones who signed the settlement in the very first sentence that says, and I'm quoting, the settling parties hereby propose a complete settlement of all issues that were raised or could have been raised. And we're the ones down here now having to deal with the second brief, the second series of briefs and arguments on a matter that we feel is moot. I think it's clearly moot, and it's clearly advisory opinion, and I don't really understand why we're here. So I'm adopting completely fairly brief, which I agree with your comments. I thought was very well done. And her argument that I think this is a moot issue again.
Mr. Quidon?
Yes, Your Honor. My purpose of being here on behalf of the Delaware Energy Users Group is to support a settlement that I believe you've heard everyone is in complete support of, every party, including staff. So unless this issue would somehow change that, it seems to me that you don't need to address the issue that comes with, and the settlement should be approved unless there's something that gives you grounds to hesitate, and there's nothing. There's more than sufficient evidence in the record, with or without the testimony of Mr. Gorman, to support what was a very hard-fought, bare-knuckles settlement negotiation that resulted in complete agreement of all the parties.
Point of clarification, I was not heard correctly. I said not as concerned. We're asking the commission to basically overturn the hearing examiner's decision to the limited extent that exhibit, I should know the number, the exhibit number attached to Mr. Gorman's testimony not be admitted into the record. That's the only thing that we're asking for, and for the reasons going forward that may create issues.
Commissioners, anybody have any questions of the parties?
Yes, Mr. Chair. I have 4 questions. Start with staff. Mr. Geddes, you gave a handout here, and you referenced some paragraphs. This is from PSC 14-132, and there is a sentence in paragraph 323 at the bottom of page 129. It says, "We direct staff to investigate and report back to us as to whether other states such as Maryland, Jersey, Pennsylvania have guidelines or process rules that address substitution of witnesses." What are the findings from that?
Your Honor, I do not know. When I was reviewing the decision, I was reminded that that was part of it, and I will endeavor to inquire whether any kind of review.
Are you of the opinion that findings from such an action might provide more clarity or benchmarking for this commission?
I always believe that additional information is better than less. It provides context, so yes, but I don't know what the quality of that information would be, but I certainly think it's useful to try to comply with that directive.
Okay. Second question. Why did staff acquiesce to a settlement if this witness issue was still pending?
It wasn't pending when we acquiesced to it. The night before, we were negotiating. We did not believe that this witness was going to be there, given the hard-fought contest in terms of the fact that Ms. Iori did not want that witness to support a settlement that was higher in revenue and rate of return. It was the next day. There was a letter filed at some point. I believe it was after we had negotiated the agreement where Ms. Iori indicated, well, if you're going to have a new agreement, we want the testimony in, but if you don't, we do not want the testimony in. So we were not aware of Ms. Iori's position until the following morning that she was really going to, given the terms that were in front of everybody then, that she was going to seek to have Mr. Gorman's testimony there. We weren't aware of that. We thought it was motion to quash had been not resolved, but we were going to go forward with a settlement.
So you were of the view that all open issues from the staff's perspective had been resolved and then something changed?
We were not aware that the Gorman issue was on the table anymore.
Okay. Third question. Why did staff not cross-examine witness Watkins?
Because the issue with regard to the rate of return had been reduced. And the fact that our issue was not Mr. Watkins' testimony or his reliance on Mr. Gorman, it was the marking and admitting of the exhibit. Mr. Watkins can certainly rely on Mr. Gorman or whomever else he wants to, any learned treatise, but it was the fact that they were seeking, in addition to mark pre-filed written testimony as an exhibit in the proceeding. And that was what we were objecting to. I had no questions for Mr.
Watkins,
because we had agreed to a rate of return, which was lower than the day before, and therefore there was no basis on which to cross-examine him. I was not concerned with Mr. Watkins' testimony.
Okay, and the last question, and this could be for anyone, are we missing the forest for the trees here, especially since it seems to me like the ratepayers have settlement costs 1/2 the initial proposal?
They do have settlement costs of 52%, I believe, of the original proposal, which is very good. Contested cases, as you know from your experience, it's rare that they, fall out in that level, although sometimes they do. But I don't think it's the forest of the trees or getting down in the weeds and not being able to see the sky. I think as long as I've sat in this chair, I've always tried to look out into the future. And lawyers are trained to look for imaginary horribles. And I think that we would not be here if the hearing examiner had not made that first sentence. The second sentence I could probably live with. But the first sentence, I think, is a problem. That because a selling party is pushing a proposal, somehow they give up all their rights to stipulate or non-stipulate, if you will, because I know Ms. Ireland doesn't like the word objection, to anything that might come in the record. And remember, it still creates a burden. You have to address it. Anything that's in the record as an exhibit has to be addressed as evidence.
No further questions, Mr. Chair. Thank you, Mr. Geddes.
I have a question, Mr. Geddes. There was an objection by the DPA before March 8th
Yes.
as to staff using Mr. Gorman as an expert witness. Is that correct?
Yes.
And so he wasn't, except for Mr. Watkins. Go ahead.
If I can flesh that out just a little bit. We notified the DPA that we wanted to call Mr. Gorman, but he's a good witness, because we thought it would be helpful to staff's position with regard to what the proper rate of return would be. We were told that they would not produce them voluntarily. We filed a motion for a subpoena. DPA filed a response trying to quash this subpoena. We filed a response of pleading in connection with their motion. And at the time the case was settled, that's the status. The hearing examiner did not rule on it, and in fact, I believe on the page I attached, he did say that he hadn't ruled on that. So the issue of the appropriateness of the subpoena and the opposition to it there's no decision on that. But we had tried to get Mr. Gorman there to the hearing room and were unsuccessful.
So the fact that his testimony was ultimately included as an exhibit to the settlement in a way, isn't that what you wanted?
I wanted the witness there on the 7th to testify on the public interest. I was unsuccessful in that. On the 8th, when the staff had negotiated a different deal with Delmarva, a better deal, if you will, I did not think that Mr. Gorman's testimony was relevant to the rate of return that we were able to establish with Delmarva, which was their existing rate of return. And therefore, his appearance was not necessary to support the settlement. And I was very surprised when they said, they being counsel for the EPA, that they wanted his testimony admitted into the record. And that's when the staff objected and said, no, we're not going to stipulate to that.
Thank you.
I have having a hard time figuring out what sort of harm staff has suffered as a result of the exhibit being admitted under the circumstances we've just discussed.
The harm is that I think it creates a bad precedent going forward because of the arguments I made before. It opens the door that in the future, if you're selling party, you just have to stand by and watch all the pre-file testimony come in. And you have an additional burden, and you have to deal with it, in your opinion.
I have a question.
Mr. Commissioner Correa.
The fact that the settlement was done in a big interest from a forest point of view, not the tree point of view. So it's a big goal is achieved with a compromise and discussions and what have you. To me, it doesn't affect my thinking about what was done, not done, testimony night before, changing the mind day after, and what have you. So I would not consider that as an item to in my mind evaluate whether, because what he's asking for is a legal step which will affect the future cases. So that is my reasoning of agreeing with him that the fact that settlement was done, it would have been done anyway, both ways, if it was allowed or not. So, because it was all agreed upon the meat of the problem was resolved by all the parties. So it is a matter of legal steps and what happened and what have you. My question to you, Mr. Redis, is that suppose we don't do anything, and it will affect the future case studies. But when the future case comes to us, can we not add at that time that no, it should be allowed? But today we don't do anything. We don't allow it consciously and knowingly that even though the big picture is not important right now because you are talking about steps and what happened and what the staff did or thought. So suppose we don't do anything. And 2 years from now we have another case like this. Can we still not add anything to that?
Well, let me answer. I think there are two questions in that. The first one is that by not doing anything, you would adopt the hearing examiner's report, which has the reasoning which staff is accepting to. So I'm not sure that's a viable option to the extent you're concerned about it. Going forward, you can always change your position, but you'd have to then articulate, and consistent with the Chesapeake decision, the reasons why you are changing your position on this particular issue. Probably the preferred method as an alternative, B or C, is to strike a footnote and not have the issue per se resolved because it wasn't spoken to, even though people will go back and argue that the transcript is the decision. But the fact that the commission did not include it in the hearing examiner's report would be better than nothing. not preferred, but as a way to do it. But by not doing anything, then the hearing examiner's decision would have some precedential value going forward.
I happen to like that because it still makes a note that we did hear about it, we looked at both the sides, and we made a decision based on, to put a footnote, based on what we think at this point of time is the right thing because everything has gone forward so well. That is my thinking right now. So,
Mr. Chair, Commissioner Correa, I'm not sure whether I heard these two issues, the settlement on the broad settlement on the one side moving forward, and the process and precedential issues for the future are severable. Are they one package that both need to move together forward, or can they be separated and decided at separate times? And let me just give a little context as to why I asked that question, because I heard two things. One, hearing examiner, there was a motion, and the hearing examiner did not make a decision on whether or not to allow this information. And the second is I didn't really hear that staff has generated any findings from the benchmarking that are directed in this previous order, where it says investigate and report back. So that's why I'm asking the question about severability, whether not deciding this point today undermines the broader settlement agreement.
Let me try to answer it globally and then maybe more specific. This particular evidentiary issue, I do not think has to be resolved today. Because whether Mr. Gorman's testimony is in or out, I think most people would agree that there's plenty of testimony to support the settlement. Now, procedurally, if it's not resolved, either through elimination of a footnote or some other mechanism, it's not time sensitive. And if Commissioner, your point is that you want to receive the benchmarking that was requested a year and a half ago prior to resolving this, if that's the import of your question, I think we obviously could figure out a way to do that.
What does that do to this settlement?
I don't think it does anything to this settlement. I mean, the commission can adopt whatever portions of the hearing examiner's report at once, or it can make it own. So if you agree that you want to not resolve the exception that staff brought and remove the footnote from the hearing examiner's report, that would just leave the transcript, but it would not resolve the issue per se, although it was admitted by his ruling below. It's not staff's desired result. I told you what that was, but it's better than having this be precedent going forward.
Ms. Iwari, if I were to make a motion to accept the settlement and then make the reasons by the hearing examiner admitted the exhibit into evidence, excise that, and also state that we would like to hear this issue, but we'd like to hear it the next time it crops up, and that we would give great consideration to hearing an interlocutory appeal and make the decision on the merits the next time this issue arises. To be honest with you, there's been like no harm. I mean, there was a settlement by all the parties, really no harm involved except for what I would call, an important issue that Mr. Geddes is arguing. But it's not so important that we can't put that off to another day, especially if the next time it happens is a time that we actually address it on the merits in a given case. And it's unlikely that it's going to happen again, that everyone is settling the case and then still fighting over some piece of evidence that was admitted into evidence or wasn't admitted into evidence. Can I make myself at all clear or confused?
Yes, but I'm not sure whether you're asking me a question or not.
Do you have any objection to that?
I have no objection to removing the footnote from the hearing examiner's recommendations. I don't know that I necessarily agree with all the other stuff you said, but.
Okay, I'm just
And I
trying
would
to,
not, we would not object to removing that footnote.
Mr. Goodman?
No, I think that what you said is that if this comes up again and it's, for lack of a better word, and it's not what you said, and you probably use better words, but it is meaningful to that future case, then it can be decided and you will decide it. But in this case, no harm, no foul, it's moved. I agree with Ms. I have no problem. In fact, I'll stipulate to the removal of footnote 6 because it's meaningless. It's factual.
And I do not object to it.
Well, I just want to clear that, I appreciate what staff's arguing, and I saw your diagram, and I think it's important. But under the context of this particular case, I don't see why we should address it on this particularly unique circumstances. But the next time it comes up, it has to be part of the motion, but I just think it's got to be resolved. And so I just don't have this particular factual situation is just not pleasing me to do that.
Just point of clarification. Is there any way to deal with, in your motion, with the concept, which I think is what you're getting at, that the hearing examiner's determination on the record is, has no presidential effect going forward?
Correct. That's exactly right. Yeah.
Okay.
In other words, we want to make a decision on the merits next time this issue arises.
With a clean slate.
With a clean slate and with new eyes on it. And I don't ordinarily negotiate motions, but I wasn't sure what to, it seems like a good way to resolve it. Any of the commissioners have any questions about what I just said?
I would support that approach.
I would as well.
Okay, so and Mr. Geddes has got that. That's my motion, as previously stated. Settlement,
A second?
no precedential value. We want to address the issue the first time it comes up and there's an objection and resolve it on the record. Is there any discussion on the motion which has been seconded by Commissioner Drexler? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries.
Mr. Chair,
Mr. Goodman? I'm sorry, 1 second. Mr. Goodman?
Yeah, this is a side issue, but it's important. We want to get the rates for this in June 1st. So, will we get a written order today?
Well, I thought the order said June 1st when I reviewed it.
So we'll be signing today.
48.
I think, yes, what I was thinking is the order that you see us first would be signed, assuming the commissioners want to sign it, and then we would have a separate order on the motion and the exceptions.
I just want to know what
It has to be resolved, and we would just do that at subsequent time. Maybe the next one.
That's it.
Mr. Chair,
Thank you.
point of order. Just
Commissioner Gray.
before we close out on this request and the motion we just made, I would like if staff would provide us the benchmarking that is called for in this previous order. That may help bring some clarification and guidance for the commission. Thank you.
Do we need to then approve the order, or that's a part of
Need a
it?
motion
We
for
just
90.
did. That's part of
Yeah,
it.
that's part of the motion.
Yeah, that was the first part of it. Okay, number 2 on the regular agenda is in the matter of the provision of renewable energy portfolio standards, compliance charge, and credit rate to retail consumers in the service territory of Delmarva Power and Light.
We just want clarification.
Sure.
That this, the motion has also, in all of that motion, order number 9048 is approved.
Correct.
As presented.
That's correct.
That's all we need. Thank you.
Thank you.
Your Honor, if I can, I'll ask to be excused. That was the only matter on which I needed to appear.
You're not interested in the other thing?
He's not getting paid by the hour, Your Honor. It's a flat fee.
And somebody's playing baseball, so.
Thank you. Thank you.
Thank you, Your Honor.
Ms. Scott?
Thank you, Chair Winslow. This is the order to implement on an interim basis the 2017 Renewable Energy Portfolio Standards Compliant Charge Rate and Credit Rate to be implemented subject to refund as of June 1st, and also requires that we proceed to publish notice of the proposed rates in the News Journal and the Delaware State News. It also sets the deadline for intervention of interested parties. Delmarva has reviewed and worked with staff and DPA on the form of the order and asked that it be adopted as presented.
Thank you, Ms. Scott. Mr. Willard?
Yes, we agree. Again, the application was submitted in March. There's a lot to it with the reasonable energy credits and the solar energy credits and all that kind of stuff. And this is an order to temporarily allow it subject to refund. And as she said, there'll be parties can intervene up until July 25th, I believe it is. And the staff would recommend that the commissioners adopt order number 9062.
Thank you, Mr. Willard. Ms. Iori?
Nothing to add to what has already been said.
I don't believe there's anybody else here that wants to speak to that issue. Any commissioners have any questions? May we please have a motion?
I move that we adopt order number 9062.
And I second.
Is there any discussion on the motion to approve the proposed order number 9062? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Any abstentions? The motion carries. Number 3 on the calendar is in the matter of the provision of standard offer supply to retail consumers in the service of Delmarva Power and Light Company. And I assume it's once again Ms. Scott.
Yes, thank you, Chair Winslow and Commissioners. Similar to Order 9062, this order is with respect to the standard office service rates, procurement cost adjustment, and reasonable allowance for retail margin. The order would allow these rates to go into effect subject to refund as of June 1st. It also sets the requirements to publish notice as to the proposed rates and sets a deadline for intervention of July 28th, 2017. And we ask that this order be approved as submitted.
Thank you, Ms. Scott. Mr. Willard?
Yes, we agree, Your Honor. Again, the Commission in order number 7461 previously approved Delmarva's request to utilize reverse auction in its annual SOS procurement process. And in November 2016, January 2017, they conducted their 12th annual procurement in 2 tranches, which were supervised by staff, etc. Liberty presented a report to the Commission back in February, approving everything, and staff recommends that you approve the final Liberty report, which was presented on February 23rd, and allow the rate to take effect on June 1st, and adopt order number 9063.
Thank you, Mr. Willard. Ms. Iori?
Again, nothing to add to what's already been said.
Thank you. Questions, commissioners?
Mr. Chair, I move enthusiastically. This rate looks like it's going down.
Yes, it is.
That the Commission adopt order number 9063 as submitted.
I second.
Any discussion on the motion to approve the order? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you all.
Thank you.
Next one is in the matter of the Commission's review of Delmarva Power's retail electricity pricing potential and long-term approaches to secure lower-priced energy. Now, this one is an important one. I don't mean to try to short-circuit things at all, but there's a very nice report by The Economist. Everybody else did really nice. They really sort of engaged on the issues. So I don't think we necessarily have to go over, unless some commissioners have some questions, the entire London economic report. That would be disastrous. But the reason I was wondering about Mr. Quinahan was that it would be nice if some of those people were here for this discussion, but they're not. We got Ms. Knotts here from staff, who's an expert, and we got Mr. Goodman. So I guess, Mr. Geddes, you're going to start us off. And
I'd be happy to. I believe this is a consensual order. I know it's been circulated.
Okay.
The order itself goes through the history of the request and the fact that our comments have been considered, and also the evaluation of the London Economic International report, and in the wherefore clauses, simply that the parties agree, those who commented, that Delmarva should begin procuring through the reverse auction process 2-year ladder fixed price full requirements contract for its residential and small commercial industrial customers.
Where's Mr. Green?
You got part of what he wanted, Joe. You got a shorter
He
contract.
didn't get months, but he got
Yeah.
he got 2 years.
33% reduction. That was
Well,
his concern.
That wasn't my only thought on this particular case. He had an interesting idea about some of the industrial users, was it? I forget the classification. Ms. Knotts?
Yes, he advocated for shorter contracts for them also.
And what was the staff's position on that?
Actually, this docket, we looked at the risky, the residential and small commercial industrial customers, and that's what we concentrated on here.
Okay. So what's going to happen with his idea? The reason I said to myself, well, he's not going to win on this because we're probably not going to go from 3 to 1 in one fell swoop because of the variability issue. But it's intriguing to get some sort of a pilot case almost as part of a classification to look at a shorter one before we actually perhaps go to a shorter one. So I wasn't sure what the thinking was around the table, so I did want to bring it up and discuss it.
LEI did not look at anything but the residential, small commercial, and industrial. So, we could certainly look at that, in another docket if we wanted to look at maybe the MGS, LGS, GST, that weren't taking any kind of HPS hourly price service. We could look at shorter contracts and have a hire consultant or whatever to see what we do.
Well, I'm just raising the question. There doesn't seem to be a whole lot of demand for that issue right now. I mean, there's no one at the table from. Of course, it's, as you said, it's for risky, so they weren't expected to be at the table. I should maybe look for them because the stock is not about them. Ms. Iwari, straighten me out, please.
Not to straighten you out, I just wanted to point out that most of the big industrial customers that, say, Mr. Quinnan represents are obtaining their supply from alternative suppliers.
I would say all. When you mentioned Mr. Quinn, who represents Duke, leaving, I can tell you that the Duke members are all on. They go out and they shop. They're very sophisticated. In fact, one of them actually is a supplier itself. They're actually registered with PJM to do the work themselves. That's how sophisticated some of those are. And even maybe the smaller customers in those classes, I would hesitate to, I don't know the exact answer, but I would say that there are times when none of them are on SOS. And when they are, it's a very short period. We're talking very sophisticated business entities. And I think that's why staff recommended that it be a residential and small commercial only, because those are the ones who need to rely on something like SOS.
Okay,
but I don't want to speak for staff.
That makes a lot of sense. So the Lindys of the world, we don't have to worry about. You're just telling me.
Right. Of course, I didn't say Lindy. I didn't want to say Lindy, but you're right.
They're taking care of themselves.
They are very advanced. They're their own supplier. It's impressive.
Okay. Thank you all very much. Commissioners, any questions?
A couple of clarifying questions. I noted in the order that during the transition there may be contracts shorter than 2 years for the next several delivery years until all the contracts are 2-year fixed price full requirement contracts. Do you foresee moving in this direction by prototyping the duration of time for these contracts, or will you get a consultant to do additional modeling to actually analyze how to transition?
No, we will not get another consultant. We will actually transition. In fact, I don't want to speak for Delmarva, but in talking to some of my colleagues at PHI, Maryland has gone to a similar transition a while back from 3-year to 2-year. So there is a transition plan that we can work on to transition to that.
No further questions, Chair.
So, excuse me, just to clarify a little bit more, we do contemplate on putting that into effect for the delivery year 2018. So we would start the tranches this fall.
Okay. Sounds terrific. Anybody have a motion so we can...
Chair, I move that the motion adopt Finance Order Number 9064 as submitted.
And I second.
Any discussion on the order on the motion to approve Order 9064? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Any abstentions? Passes. Thank you very much. There's nothing on the hearing schedule. Is there anyone here from the public that wishes to make public comment? Is Tom Noyes here? Anybody from Denrec that wishes to make any comments? Unfortunately, we don't have John Farber today.
He's here.
Well, for comments.
Oh, sorry.
Director's comments. Let's go over John's head. Mr. Howell.
Chairman Winslow, Commissioners, I have a long and lengthy list of administrative matters to discuss with you today. I'll top that off with just letting you know that our next commission meeting is on Tuesday, June the 6th, 2017, starting at 1 p.m.
Thank you, Mr. Howell. Okay, the meeting is adjourned.